Let's go on a record. Good morning. I'm board member Stacy Moniz, and I'll be presiding over today's proceeding. Also present are board chair Marcus Oshiro, and by Zoom, board member Cesanita Moipono. Today is January 22nd, 2024. The time is 9 a.m. We are here today regarding case numbers 23 CE 05976, 23 CU 05400, 23 CE 05978, and 23 CU 05398. And this is the matter of Donna Campbell, David Reid, and Cecilia Therese Best, and the Department of Education and the Hawaii State Teachers Association. This is the first day of the hearing on the merits. Would each party or their representative please enter their appearances for the record, beginning with the complainants, Mr. Reid.
Morning, I am David Reid. I represent
Thank you, Mr. Reid. And also present are thank you. Good morning. Thank you. Good morning. Mr. Takei. Thank you. Good morning. Mr. Alapa.
Good morning, Chair, board members, Kiani Alapa for responding HSTA. Also present is Deputy Executive Director Andrea Eshelman for HSTA. Thank you.
Thank you. Good morning. Due to budget restraints, the board will not provide a court reporter for any proceedings before the board. All matters will be recorded through Zoom as the official record. If a court reporter is hired by a party or parties, then the party at approximately 4 p.m. and we usually take a 1.5 hour lunch each day. The witness exclusionary rule is in effect. Party representatives who are testifying can remain in the hearing. And I know we have a preliminary matter regarding additional exhibits that Mr. Reid submitted and Mr. Alapa lodged his objections to. Two of the exhibits, I believe, had no objection, which I believe were 22 and 25. Everyone's understanding, I believe Mr. Alapa's objections went to 21, 23, and 24. So with that said, we will admit exhibits 22 and 25, and not to confuse matters even further. For our purposes, those two exhibits will be consecutively numbered as now 21 and 22. The other three exhibits that Mr. Alapa lodged his objection to, those have been offered. We're going to reserve ruling on that when they're used or brought up. So at this point, they're not in evidence, but we'll reserve ruling on that. Any other matters that the parties wish to raise? before we begin with opening statements? Mr. Takei?
Nothing.
So, Mr. Reid, are you prepared or wish to make an opening statement?
I do.
Proceed.
Whatever's most comfortable.
What?
We are, sorry, this is my first rodeo. We are here today, because we have seen, what we view as an injustice. What we will prove, throughout the course of these hearings, the evidence will show that the repricing was illegal under 89.9 F2. The evidence will show that it was obviously supposed to be done under F1. The evidence will show that this was done in the full knowledge of the facts by both parties, by both respondents, and that the evidence will show that it's allowed to persist. And once the repricing is what after that, everything that happened as the result of it is just, as I say, fruit of the poisonous tree. They didn't have the power to lean on, or they didn't have the right, or the evidence would show that they didn't have the right to lean on the expression at the discretion of the employer, which is their reason for their justification for taking away the 6 years of prior accepted experience. Is their justification for everything. Everything boils down to at the discretion of the employer. And in this case, you don't even have to argue what discretion is, because you have the discretion to begin with, because it was clearly an illegal repricing. So that means that everything had it been done under F1 as it was supposed to, it would have required negotiations, required agreement, would have required collective bargaining to happen. And collective bargaining did not happen. And that is what the evidence will show. That is why we're here.
Thank you, Mr. Reid. Ms. Campbell or Ms. Bass, do you have anything to add? Mr. Takei, you wish to make an opening statement?
Yes.
Please proceed.
May I remain seated as well?
That's fine. Whatever your preference is.
So. Oh,
Green means go.
DOE implemented repricing that reassigned the step placement of all future classes on the salary schedule based on BU5 service duration. Repricing was designed to address teacher salary compression and recruiting issues. Non-BU5 service was not considered because it did not represent service that experienced the same salary compression as BU5 teachers. Repricing did not impact the CBA, and it did not have a negative impact on any teacher's wages or benefits. Repricing was funded by Act 248 of the legislature. The legislature did not require repricing to be negotiated. Repricing was utilized under HRS 89.9 F2. This provision clearly conferred upon DOE the discretionary authority to implement repricing without collective bargaining. During the development of the repricing plan, DOE consulted with HSTA but did not negotiate. Both parties agreed negotiation was not necessary because it was at employer's discretion under 89.9 F2. It did not change the CBA. It did not take any rights or pay away from teachers, and the plan benefited teachers who experienced compression. Complainants argued that repricing needed to be negotiated under 89.9. It did not. 89.9 F2 states that it does not. In addition, complainants as employees do not have standing to allege a violation under 89.9. Only the employer and exclusive representative have that right. Complainants argue that not negotiating repricing violates an employee right under 89-3. complainants never stated which right under 89-3 was violated. Regardless, there was no violation. There's no employee right under 89-3 to compel DOE and HSTA to negotiate repricing, which is discretionary under 89-9 F2. Also, none of the rights listed in 89-3 were violated because DOE did not interfere, coerce, or restrain complainants from exercising their right to self-organize and have a union represent their interests. In fact, they are self-organized under HSTA that represents their interests. And there was no collective bargaining that DOE could have interfered with or coerced complainants out of or restrain complainants from. Complainants argue that repricing violated the merit principle of equal work for equal pay. It did not. That principle applies only to work within the same bargaining unit. There is no right to get paid equally for non-BU5 work performed outside the bargaining unit. Complainants argue that repricing violated the CBA by not considering BU5 service, thereby resulting in non-tandem step placement with in-service teachers with equal years of service with whom they were initially placed. The CBA does not guarantee tandem step placement except during initial placement. So this argument fails. Finally, complainants argue that repricing was discriminatory against mainland teachers who they claim to be predominantly white. It was not discriminatory. Anybody born and raised anywhere, regardless of race, can get BU5 service as long as they are a BU5 member. I have nothing further to add.
Thank you, Mr. Takei. Mr. Alapa, you wish to make an opening statement?
Yes, board member, and I'll remain seated since the rest of the parties are, just to be consistent.
That's fine.
And I understand that today's proceedings are for the employer's case. The union will go after that case is done, but I just wanted to give a real brief snapshot of how we view this case. The employer, has utilized 89 F2, their discretionary function. Even with that said, the union did go through the negotiating process. And what I mean by that is they met with the employer, they consulted, they reviewed, they analyzed, and they made a decision. They made a decision not to demand impact bargaining. And there's a basis for that. It wasn't arbitrary, it wasn't discriminatory, there's a basis for that. This issue on salary compression has existed for decades, for a very long time. And the union has fought and fought and fought to get this done. And it hasn't accomplished this for many, many years. Now there's a surplus in the budget, there's some money available. And this was a unique opportunity to get something done on an issue that's been lingering over the HSTA and the DOE for a very long time. The proposal and the plan by the employer address a vast majority, over 9,000 members of HSTA. It didn't get everyone, but it got a vast majority, a very large majority of its members. And it gave them additional benefits. It didn't take benefits away from anyone. What it didn't do is it did not provide those same benefits to BU5 members who didn't have BU5 service time during the salary compressions. So the employer's position was, we're going to address the 9,000 plus who suffered through the salary compressions. They're not going to address those who worked elsewhere during that time. The union consulted with the employer. They tried to get everyone covered. The employer declined. So at that point in time, the union had to make a decision. Are we going to allow the 9,000 plus members to get this additional benefit? There's a good faith basis for the employer to provide it to them. Or were they going to stop the whole thing, demand negotiations, impact bargaining, and stop the implementation and potentially face over 9,000 DFR claims from members who would have lost a significant portion of their benefits that the employer was offering? So that was a conundrum that the union had to deal with at that point in time, and they had to make a decision. The union is given that discretion under our collective bargaining laws to make those decisions. And it was a good plan. It benefited the majority of the membership. The union didn't stop there. You'll hear testimony and evidence that concurrently, the union did demand bargaining and negotiate with the employer as part of their contract negotiations for those members that didn't receive benefits from the compression fix. They sat down, they bargained and negotiated.
Is this an open meeting about
It's an opening statement.
he's allowed
Yes,
to
because-
present?
This is just his position, it's not evidence.
And as I mentioned, the evidence will show that concurrently, the union demanded bargaining as part of his contract negotiations, sat down with the employer, negotiated to cover those members that didn't receive proceeds from the compression fix. The employer declined through negotiations. Under 89A, we cannot compel the employer. That's an ongoing battle. It's an ongoing goal for the union. They plan, as the evidence will show, to continue those negotiations. So looking at the broad picture, there's a basis for what happened. It provided a great benefit to a majority of the members. The union did what they could, and they continue to fight to try and cover the members that did not receive the compression fix. So the evidence will show that nothing here was done on behalf of the union in bad faith. Nothing was discriminatory. And the union did its best with what it was given. Thank you.
Thank you, Mr. Alapa. Mr. Reid, are you ready to proceed with your case?
Yes,
And please call your first witness.
ready. Andrew Eshelman.
Are you
How do I do
calling,
this?
are you calling Andrea Eshelman?
Yes, I'm calling Andrew Eshelman. That's my first.
Ms. Eshelman, if you will. Take the seat up here.
Sitting,
Pardon me?
sit, or,
You can see, I'll swear you in.
okay, I wasn't sure if you want me to.
Board member, if I may, before we start, I just wanted a housekeeping item. Today during the proceeding, will each party on the complaint side be allowed to object, or are we just gonna have one voice? Just want to get it kind of coordinated.
Well, that's a good question, Mr. Alapa. Mr. Reid, do you intend to do the questioning on behalf of yourself and Ms. Campbell and Ms. Best?
Yes,
So Ms. Campbell and Ms. Best, you won't be of this witness.
I think that I'd like to reserve the right to ask questions. We have 3 individual cases, even though we have combined cases as one. Simply for time, for me to confer with Mr. Reid, talk about it, and then have him ask questions seems to be somewhat not a waste of time, but if I have a question, I would like to give at that time.
I guess the issue for the board, Ms. Campbell, is that, and we began this proceeding this morning with Mr. Reid saying he's representing
Yes.
everyone. And so in that sense, you actually get one bite of the apple. If Mr. Reid asks the questions, it's going to be Mr. Reid that asks the questions. That's been the representation to the board. You can have whatever time you need to confer
Okay.
with Mr. Reid to allow him to ask the questions, but at this point in the proceeding, we'll proceed with Mr. Reid asking questions on behalf of all the complainants. Okay? So, Ms. Eshelman, will you solemnly affirm that the testimonies you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
And can you please state and spell your first and last name for the record?
Andrea, Andrea, Eshelman, Eshelman.
Thank you. Mr. Reid?
good morning. Tell us about your educational background and work history with labor union.
Educational background and work history. I have a bachelor's in education. and I worked for nearly 10 years with the Department of Education as a teacher, and I've worked for the Hawaii State Teachers Association for 19 years.
Do you have any legal training?
I have had a variety of training over the years through my work with HSTA, yes.
What is your job with the Hawaii State Teachers Association?
I'm the Deputy Executive Director and the Chief Negotiator.
Is knowledge of Hawaii Right Statute Chapter 89 a professional responsibility for you?
Yes, I oversee enforcement of the contract, which has to do with Chapter 89.
And were you the primary point of contact with regards to HSTA's interactions with the DOE with the compression fix?
Myself, my negotiation specialist, as well as members of our bargaining team, all had various contact with the department.
Who is your negotiation specialist?
Colleen Bird.
An EMP is an experimental modernization project authorized by HRS 78-3.5. Are you aware of this?
I'm aware of the concept, yes.
Look at exhibit RU1. It's U10 on the
When dated
Third
December
section.
5th, 2019.
yes.
Okay.
This describes a pilot project that is going to be this letter references it happening in the near future. This pilot project, to your knowledge, was the HSTA involved with any feedback or suggestions or requests for this pilot project?
Yes, we were in discussions in the fall of 2019 with Superintendent Kishimoto.
And was that pilot project repricing?
I'm sorry?
Was that pilot project repricing?
This was a pilot project to address teacher salaries that Kishimoto wanted to implement, but it did not get implemented due to COVID impacts of the budget.
So was it repricing or an EMP?
She was proposing to implement an EMP.
At this point in the process, did the Hawaii Department of Education mention repricing? Was it on the table? Was that part of the conversations, or was it strictly an EMP?
Could you clarify what you mean by this point?
In the conversations that led up to the creation of this memo that describes a forthcoming pilot project, was repricing an idea? Was repricing? Did the DOE discuss repricing with the union in the discussions that led up to this memo?
In the fall of 2019?
Yes.
To tell you the truth, the discussions were broadly about how do we make adjustments to address compression? And there were a lot of different discussions about how that could happen. This was what she decided to propose and put to the board. We were not involved necessarily in the drafting of this memo per se.
But did the union have conversations with the employer that led to?
We've been having conversations with the employer for over a decade on how to address compression.
And over the course of that time period, how many times was repricing specifically mentioned?
I wouldn't be able to answer that question. I've been the chief negotiator for almost 10 years. It's a topic that has been discussed.
And it's well, discussed when?
I'm not sure. So the concept of addressing compression
No.
has been
Well,
addressed multiple times.
Suggestion, she can finish.
Mr. Reid, allow Ms. Eshelman to finish her answer. Thank you.
The concept of addressing compression has been discussed over and over and over in a variety of different forms and functions. Lots of different vehicles have been looked at. I cannot tell you how many times repricing. I cannot actually tell you the first time the word repricing was suggested by the employer. I do not recall.
Can we look at exhibit Exhibit CU1. Six, C-6, P1, page 6. It says for years, HSTA.
You said 6?
That was the wrong page. Give me 1 second. Here we go. Sorry, CU1, page 2.
Page 2?
Says the governor and the executive can do this through repricing.
Mr. Reid, hold on 1 second.
Okay.
Can you allow discussion in the,
I'm
Okay.
there.
okay,
Thank you.
proceed.
Says, the governor and the executive can do this through repricing. So that's the type of language we're using this year. It should be repricing. And the date on this email is May 3rd, 2022. Do you have any documentation from the DOE that would indicate that repricing was specifically a focused point of effort in the creation of this process prior to approximately beginning of May 2022?
Could you repeat that? That was a long question.
Has the union received any documentation from the Hawaii Department of Education that repricing was going to be the vehicle to accomplish the compression fix prior to the date of
Documentation.
this?
I don't have a memo or anything like that, no.
You
The
haven't-
first official documentation that was put out was the October memo to the Board of Education.
October 7th, 2022.
When they went to the Board of Education and said, we've decided to do this implementation to address compression.
So that was the first time that, just to be clear, that was the first time that the union had heard about repricing.
No, that's not what I said. You asked about documents.
Okay. I'll look at exhibit CU2,
Mhm.
page 1. It's 0009.
Okay.
First paragraph of the executive summary, pursuant to Hawaii revised statutes.
Excuse me, Mr. Reid, can you identify the exhibit, the date of the exhibit and what it is?
January 16th, 2020, it is the Board of Education memo from Dr. Kishimoto to the Board of Education.
Thank you.
It says pursuant to Hawaii revised statutes, HRS 78-3.5, experimental modernization projects, EMP. I am planning to conduct an EMP in response to concerns reported by the Department of Education and the Hawaii State Teachers Association. How did you express these concerns to the employer? How did the employer receive these concerns from the Hawaii State Teachers Association?
Well, like I said, this is not a singular year issue. The issue of compression has been something we've been dealing with since the early 2000s. So there have been ongoing discussions. If you read this memo, you'll also, there's, I believe in this memo, discussions about a salary study that was done. So we worked with the department on that. So there was lots of discussions on this topic.
At the time this memo was written,
Mhm.
had you discussed repricing specifically under Chapter 899F 1 or 2 with the Department of Education?
At the time this memo was written, we had discussed the need to address compression, and the superintendent indicated that she wanted to use this vehicle, the experimental modernization project.
No.
That was not, repricing was not a vehicle that she was looking at that time. That superintendent did not look at that. The new superintendent looked at a different one.
And then COVID happened, it sort of delayed everything, correct?
March 2020 shut the legislative session down. The superintendent had been in discussions after this memo went to the board to secure funding from the legislature, and everything was shut down. So there was no bill that was active or an ability for her to get the money to do it. And that money did not come available until July of 2022 under a new superintendent.
Did the DOE have any discussions with the HSTA after this memo in 2022 with regards to repricing specifically?
After this memo in 2022,
I'm sorry, 2020.
there were a few just sort of preliminary discussions that have gone back and forth. Like I said, there was a bill. So this is in January of 2020. This is just as the legislative session was opening. So through the rest of January, February, and I apologize, I don't remember the bill number, there was an active bill to address the funding component, because you have to have money set aside by the legislature to do this type of stuff. So there was ongoing discussion. That was not necessarily by myself, that was by other staff members and or HSTA leaders who have responsibilities for working at the legislature on those things.
But those discussions, do they involve specifically repricing?
The vehicle that the superintendent had chosen was to do an experimental modernization project.
And is that the same thing for 2021?
2021, I'm not sure I understand.
Was the intention of the Hawaii Department of Education to still accomplish an EMP?
In 2021, we were dealing with severe budget cuts and trying to prevent furloughs and pay cuts. So there was no discussion about any compression fix it from March of 2020 through us settling our contract in 2021 for no pay raises for the next 2 years.
And did the Hawaii Department of Education have any discussions with the HSTA concerning repricing in 2022?
There was a discussion in 2022, and that ended up resulting in the memo that came out from Superintendent Hayashi to the board in October of 2022. And the vehicle that he chose was repricing.
So I'm not looking for an exact date here, but approximately when was the proposed compression fix change from an EMP to repricing under 89.9 F2?
I don't know. All I can tell you is that the former superintendent put that memo out, and the current superintendent put out the memo that you know in October 2022.
Exhibit CU, yeah, well, I will do it again. Just to be clear, your email, exhibit 01 from me. The email, the member matters email dated May 3rd.
I'm sorry, could you give me a number? You're going back to C?
Yeah, C step 000.
One.
One, yes.
Uh-huh.
Well, sorry, page two of the first exhibit. It says that the HSTA member matters email says that repricing is the term we're using in 2022. Is that correct?
I'm sorry, where are you?
It is the third
Wait,
paragraph. at the bottom.
which page are we looking at?
Should I use the C numbers at the top or my numbers at the bottom? Should we just be more clear?
If you tell me the number at the
I
bottom,
think it's easier to use the date stamp on the top. That's what
Okay.
we put.
Okay.
Yep.
So C2,
2, okay, and what am I looking at?
the third paragraph from the bottom. It says repricing is the term we're using that year, meaning 2022, correct?
That's a quote from Luke, so that's not us,
You published it.
correct?
You have to have, well, do you have any?
What
do you
is the
publish-
question?
The question is, I'm just being very, very clear. That repricing, the repricing conversations, the repricing process began in 2022.
Uh-huh.
In your conversations with the Hawaii Department of Education, did the union suggest repricing or did the state suggest repricing?
The union, our focus was on addressing compression through whatever vehicle would work. So I don't recall I can't give you a specific date that there wasn't like some magical meeting that someone said, okay, we're now going to change from this vehicle to that vehicle. All I can tell you is that this is the vehicle that the superintendent said we're going to use.
So the union asked for the state to fix salary compression, and the state responded with repricing.
We had been asking the state to address salary compression through a multitude of options, either through bargaining or through the legislature or any other vehicle that we could find for over a decade. This is not a new issue. This is something that we've been fighting for and trying to address since the early 2000s.
So is it fair to say that the union requested repricing?
No. We never requested a specific vehicle. The only thing I can tell you that specifically got requested is if you go back and look at our bargaining proposals. So for multiple rounds of bargaining for many years, we have been trying to address a whole multitude of salary and compensation. And just as we did in this last round of bargaining in the fall of 22, we requested to address compression. We requested to do an actual wholesale look at everyone's teaching experience in state and out of state and make additional adjustments. That is not, it's not a new issue.
So you were looking to change wages of the bargaining unit.
When you go to the bargaining table, that's what you do, yes.
Let's look at specifically, how did the HSTA try to address salary compression?
You'd have to be more specific.
Sorry, object. My understanding today is that the session is being called based on her communications with the Department of Education. We agreed to having her called twice as a witness based on that narrow premise. And I don't want to give them a shot tomorrow when they call her again to ask about HSTA's actions that have nothing to do with DOE. So I object to any line of questioning that has nothing to do with the DOE and the DOE's and the HSTA's communications with DOE.
Is it, Mr. Reid, you want to respond?
Everything that they did with regards to compression was with the DOE. That particular question may.
Well, you understand.
Yeah, I understand what you said. Yeah, that question is probably a little bit.
So
I'll
if-
either rephrase or Steve.
Yeah, so if you can focus the questions on
What
the
state.
Department of Education.
Is it fair to say that the union works very closely with the Department of Education? Anytime they have ideas or concerns about wages?
Ideas or concerns could, well, they are the employer, as are the 30, I believe, 8 charter schools. So yes, we work with the employer. That's our obligation on anything having to do with collective bargaining rights.
Is the union in any is the union in possession of any documentation from the Hawaii Department of Education that would demonstrate the existence of any established procedures to periodically review the repricing of classes in accordance with 899
Any procedures to periodically review the pricing of classes? That is not something I have.
Has the Hawaii Department of Education ever given the union written documentation that was specifically from a periodic review of the repricing of classes as described in 899 F2?
Since I have been chief negotiator, I can say no, I cannot speak to prior to that.
When did you become chief negotiator?
2015.
Does the Hawaii State Teachers Association have a written agreement with the Hawaii Department of Education so that they can evaluate the repricing of classes less frequently than once every 5 years, as described in 899 F2?
No, as I indicated, I don't have any documents related to what you're asking.
can I read 899 F2 or F1 and 2?
There's a question.
Oh, well, there's a question after it. I want to read it and then ask a question.
Am I supposed to be looking at something in the book?
Well, we can't bring statutes as exhibits. I did bring it as part of my. At this point, I could probably tell it to you by memory. 899 F1 states at the beginning, at the request of the employer. 899 F2 states, not negotiated under the employer shall establish procedures to periodically review the repricing classes at least once every 5 years. And if less frequently, then they need to have an agreement with the union. And then it says the repricing of classes based on the periodic review shall be at the discretion of the employer. Based on the documentation that you have and that did the state, read my question very carefully. Based on your knowledge of written documentation of the compression fix as accomplished by the Department of Education, did the Hawaii Department of Education reprice based on a self-motivated periodic review of the repricing of classes created as a result of established procedures or at the request of the HSTA to fix compression?
I'm gonna object to stating statute 89 F2. What I thought I heard is that the way he read it, that there's language in there that the employer and the union must agree to an establishment of procedures to periodically review. That's not what the statute says. It
I
doesn't
said
say
you
it needs to
get
be an
less
agreement.
frequently than once every 5 years.
It still doesn't say there needs to be an agreement between the parties.
Mr. Reid, if you want, can you break this up and go ahead and read the statute word for word? So it's accurate, and then just try to break up your question. It was
Kind of long.
not what
It's
Mr.
hard to make
Alap was objecting to, but it was compound on many fronts.
Board, I have a copy of the statute that he's referring to. May I offer it to the witness to
I have it here too. I can read.
look at and read along with?
That's fine if no one has an objection. Maybe show it to Mr. Reid, show it to
I
Mr.
have.
Alap.
Okay.
I mean,
Oh, sure, yeah.
may I give this? Do we agree that it's the same?
Yeah.
Is that okay, Mr. Alap?
Yes, thank you.
No, sorry.
Thank you, Mr. Takei.
F1,
Hmm.
at the request of the exclusive representative and at times allowed under the collective bargaining agreement, the employer shall negotiate the repricing of classes within the bargaining unit. The negotiated repricing actions that constitute cost items shall be subject to the requirements in section 8910 and F2. If repricing has not been negotiated under paragraph 1, the employer as its jurisdiction shall ensure establishment of procedures to periodically review at least once in 5 years, unless otherwise agreed to by the parties. The repricing of classes within the bargaining unit. The repricing of classes based on the results of the periodic review shall be at the discretion of the employer. Is it fair to say that the employer, that the Department of Education repriced based on a periodic review to reprice the classes?
Is it fair to say? I'm not sure I understand the question.
To the best of your knowledge, having all the interactions you did with that the union did with the state, did the state reprice based on a periodic review, which was the result of established procedures?
I'm gonna object as sort of form of the question, the way he's asking her to speculate as to what the DOE specifically did.
Sorry.
They were there. They witnessed the creation of this repricing plan. They witnessed, they worked closely with the state, and they're in possession of their knowledge. I'm not asking them to speculate based on what they know. Is that what they observed? They were there, They were privy to all the information and they can say what the employer did.
Same objection, what he's asking her something specifically that the DOE has personal knowledge of. It's not what the union had personal knowledge of, and there's a witness coming, Mr. Bacon, who can answer this question, who the question is more appropriate for.
Okay,
I also have a similar objection. F2 is a discretionary measure of the employer, not the HSTA. So I believe Mr. Bacon, who's coming later, is in a better situation to explain what happened and how F2 applies to the DOE's actions.
Mr. Reid, anything else? to add?
Like this is a witness. By definition, a witness has observed things and the witness has observed the state do this. The witness has observed the state make the plan and implement the plan. The witness is in a position to have all of this information as the exclusive representative. The witness witnessed this happen. And I am asking whether the witness can speak to what the witness has witnessed. Like, this is the point of having a witness, so they can say what they've seen. They have the facts that they know, they have the documentation that they know, they have their knowledge. And I'm asking, based on the knowledge that the witness has, did the witness see this done? I need to rephrase. Give me a moment to think about how I can rephrase that. But the witness is here to give testimony of what they saw.
It just add for the record, based on that explanation, lacks foundation.
Okay, Mr. Reid, I think if you can rephrase your question. We'll ask a broad general question. You're going to be asking this actual her own person. Then you need to ask those questions. It's just a matter of laying the foundation for your question. So if you can rephrase and take as much time.
Do you have any direct knowledge that the state accomplished a repricing based on a periodic review, the repricing of classes?
The employer came to us and said, we want to use repricing as the vehicle, and this is what we want to do. They presented us the draft memo, which is essentially what it looks like, the October memo that went to the Board of Education, and that was their plan. So I would refer you back to the October 2022 memo from the superintendent. That was the basis of their plan. I don't have any direct information related to periodic review. That's an internal employer business. That is not something that they come to us and have to consult with us on.
Based on our last hearing, my understanding that anything within Act 146, including the testimony, can be discussed here. I included some of it as exhibits, and I realized there were a few letters from the HSTA regarding their negotiations with the Department of Education. I have included them in the very back of the folder, and I have some for it as well. I'd like to talk about, it's a part of Act 146, which we've taken judicial notice of. May I refer to those testimonies?
It's at this point, Mr. Reid, you should share whatever you intend to use with Mr. Takei and Mr. Alapa and with the board.
I have copies.
Has this been previously submitted through?
Yes, they've been previously submitted in other pleadings, so it's nothing new.
We're gonna object to the use of these documents. We didn't have it by the exhibit list and exhibit deadline. We didn't get to prepare with these exhibits in mind. Producing it for the first time when they just admitted they had it in their possession at this juncture is inappropriate.
We have, when the board has taken judicial notice, review notice, which is
Judicial.
judicial notice of Act 146. This is part of the legislative history of Act 146, which is included at the hearing, at the previous hearing. They were gonna remove all the exhibits in there because I could talk about them freely because they were already admitted into evidence. So we've already had this discussion, and it's been taken judicial notice of. It's in legislative history.
Yeah.
And their letters.
I'm a little confused. I know the complaint is presented documents related to Act 146 as part of their exhibits, and ultimately the board allowed it to go into evidence. So is this part of that, or is this something completely different? I'm not clear.
It's part of that.
If it's already in the evidence, I have no objection. I'm
I-
a little confused.
I believe it is, but again, it's difficult even for the board, not having specifically what Mr. Reid is referring to. That's why I'm asking him to share it with council, let them look at it.
And board member, if it's already in the exhibits, if you can just refer to the page, we can take a look at it here.
Mr. Reid,
It is not in the exhibits. It is a part of the Act 146.
Then if he's offering it as evidence, I have that same objection.
One more. What?
Additional objection, including this doesn't, from what I see, pertain to the case against the DOE. It's also written by President Osotui.
These letters reference negotiations that happened. They use the past tense with regards to they say negotiation as negotiated. This letter speaks to what the department did in the process. It speaks to negotiations, the department, negotiations that the HSTA is documenting that happened. Well, my questions are about the negotiations that the state did, that the Department of Education participated in. I'm asking about them, asking about what the state did in negotiations.
And again, I strongly object to springing this brand new exhibit on a witness as she's on the stand when we have deadlines provide this. I haven't read this. I need to take a look at it. It's completely inappropriate at this point.
We emailed and I specifically said that I wanted, the conversation went like this. I wanted Osatui to come, and we agreed that Ms. Eshelman would speak to Osatui's letters, and that's what we're here to do.
That's not accurate. He asked if he needed to subpoena Osatui, and I said that's up to him, but I will bring Andrew Eshelman and he can ask whatever he wants to ask, subject to my objections. I didn't agree that she had personal knowledge on anything. If he wanted to present it at the hearing, I wouldn't have had an objection, but he did present it as an exhibit. Springing it as she's on the stand is inappropriate.
This is again part of Act 146, which we have taken, which the board has taken judicial notice of. And based on my understanding of our last hearing, they shouldn't be exhibits because they're already accepted into evidence.
The board's gonna take a short recess, subject to call.
Red.
Yeah, great. Yeah.
Okay, thank you.
A few questions, Mr. Reid, in conferring with the other board members that judicial notice was taken of Act 146, which would include the legislative history. But the board's question more, do you intend to call Mr. Tui as a witness?
I was, based on our conversations, I was under the impression that Ms. Eshleman could speak to the letters.
No,
Oh,
my
no.
question is a broader question. Do you intend to call Mr. Tui as a witness?
Originally, I considered it. As of right now, no. If we, I take these letters as not written on those two his personal behalf. They're written on behalf of the YSA Teachers Association. And as chief negotiator, Ms. Eshleman in her position should be able to speak for the Hawaii State Teachers Association, as these letters speak for the I'm assuming not Osatui's personal beliefs, but for the Hawaii State Teachers Association.
But from what I see that you presented, there were 3 different sets of testimony submitted, and it's under Osatui's name.
Yeah.
Right. There's no reference to authorship by Ms. Eshleman. Did I review that correctly?
Yes.
And so I will let you proceed, but with the caveat that you need to establish some foundation with Ms. Eshleman regarding these documents.
Yes.
Okay?
Mhm.
And Mr. Alapa, your objections noted, but again, it's subject to laying up foundation for these documents with Ms. Eshleman.
Understood. Thank you.
You can proceed.
Am I supposed to have them in front of me? Sorry.
You should.
They're in the back of they're the very
Of
back
this
the
binder?
yeah.
Oh, sorry, I
They're
did
in
not
that
realize that. Okay.
I hope you can hear me, because I can't hear anything that's going on.
Oh,
If there is
Mics
voices going on, but I haven't heard anything since the recording started.
Uh-oh.
Oh,
You can't hear me?
Let's hold on for 1 second.
Oh.
Mr. Hirata.
Sis, can you hear me?
God.
Hello, can you hear me?
Doesn't.
I guess I still can't hear anything. Can you hear me? Okay,
Yes.
thank you.
Mr. Hirata, you need some time for,
Take a recess.
yeah, let's take a
her
recess,
speak
subject
first.
to call of the chair.
Is there time for a quick restroom?
Yeah,
I'm sorry.
That's it. Technology. A blessing and a curse.
I think the words on my.
Oh, yeah. Come up.
It was on my end, this laptop.
Since I thought this could be.
So
Maybe.
I apologize. Okay, I can hear
Sis,
everything. Thank you.
Sis, can,
Yes,
Sis, can you hear me?
yes, I can. Thank you.
Okay.
Yeah, I believe I first talked to you when we first set up on funds.
That sounds familiar, yes. So much easier than having to get mail.
Andrea, I think at that time, the person who was your sister was Monica.
Yes,
She's still there.
she is, but she is now our director of admin and like facilities. My current assistant, her name is Mari. She actually used to work at right, 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 the start of the pandemic, I guess. She retired from HICO.
Okay.
And then was looking for another position, and she went to go work for you know, the IBEW unit that got in trouble with the feds. She was there for a short while, and then
Poor choice.
yeah, things were getting a little hot, so she was looking for something else, and so then she applied.
And you know, that person who got into trouble had appeared before us.
I'm sure, yes, so, yeah. Yeah, so she started with us in the fall of 2020, so right in the middle of the pandemic. Yeah, it was interesting during her interview. She had to kind of like explain why she was there.
The issue resolved. I think so, but we went on bathroom, right? So I think we're waiting on.
Yeah, I think we're waiting for everyone to come back. She got it.
Can hear, okay.
I think she can
Maybe
hear
not.
now. Yes, she's smiling, so I think that means she can hear us.
Poor Joe.
Oh, that's great. Can get a little chilly, so you need to use the restroom, just
Yeah,
signal that you're in here.
this is toilet and this is restroom.
Yes. Whatever.
We need the one for turn off the AC.
The AC.
I had forgotten that this room gets cold.
Yeah.
Gentlemen, you are the chief negotiator, correct?
Yes,
So you are aware of all negotiations that happen between the union and the state of, and the department.
Yes.
So on the letter dated March 22nd.
Just give me a minute. Go to the right one.
Second letter.
Okay, which page?
The first page.
Okay.
The fourth paragraph says, this bill is needed to address compensation equity issues and to make necessary discretionary salary adjustments for approximately 8,700 experienced teachers by recognizing their professional experience to the Department of Education and to our public charter schools through discretionary salary adjustments as negotiated. The use of the past tense seems to indicate a negotiation has happened. Did the state negotiate with the union with regards to the compression fix?
No.
I would like to look at the April 1st letter.
Chair, Mr. Reid,
Yes.
you're referring to these proposed exhibits as letters.
Oh.
But at the top of the document, it says testimony before the House Committee on Education or the testimony for the House Committee on Labor and Tourism. So I'm just getting a little confused.
Okay, yeah, I'll be more clear.
And then,
Thank you.
if I can make
Yeah.
clear, I was not a party to writing these letters, so I don't have direct knowledge of this. This was written by our state president and he is our chief spokesperson. So I'm answering the question to the knowledge I have. I'm not answering it based on the content of the letters per se. So I can't tell you what he was referring to, I guess is my point.
Sorry. This might be a little late, but I object to relevance. It seems like the highlighted passage that was just discussed was just for my clarification, negotiation between the superintendent. No, I'm sorry. Recognizing their professional service to the DOE and our public charter schools. None of the complaints are public charter school members, and so I find any questions regarding that particular highlighted underlined passage that he referred to as not relevant.
I would say he's misreading the sentence. It says, if the first part, I shouldn't. The bill is needed to address compensation equity issues and to make the necessary discretionary salary adjustment for approximately 8,700 experienced teachers. There aren't 8,700 teachers in the charter schools. That number.
Hold on, Mr. Reid. The objection's overruled.
Okay.
Proceed.
And so was there a negotiation, to your knowledge, as the chief negotiator with the union? Was there a negotiation between, as it says, the Department of Education, as negotiated between the Superintendent of Education and the exclusive representative of collective bargaining unit 5 in regards to compression?
The compression adjustments that were implemented in October of 2022 were not negotiated. This is from March. If you're asking specifically the adjustments that were made, the salary adjustments made in October of 2022, they were not negotiated. I can't tell you what he's referring to here, though. I want to make that clear. I did not write these. I do not have a responsibility to review testimony that's submitted. That is not my responsibility in my job. On occasion, I'll be asked to be consulted, but that is it. And we send hundreds of pieces of testimony every legislative session.
Do you work with OSA2E?
Yes, technically he's my boss.
As the chief negotiator, and you said one of the primary points of contact with the HSTA in regards to the compression fix. How do you give information about what do you report what you do to OSA2E?
On occasion, I do check in with him and report, yes, but I have some independent authority around all of that. So he also serves as a member of the bargaining team. So more importantly, that is why he gets information, because he's a member of the bargaining team by virtue of his position as state president. But he is the chief spokesperson. I am not the chief spokesperson. I don't write his testimony. He writes his testimony.
It's your. Is it your position that it's been your testimony that the state denied your or the union's request to include prior experience? Is that correct?
I don't believe I testified to that yet, no.
I think you said that you asked for it and that you were denied.
In the fall of 2022, we were in active bargaining for the 23-25 contract, and we did propose something in that bargain. And eventually the employer rejected it in the spring of 24. That was the contract negotiations. That was not related specifically to repricing.
23.
No, the spring of 24 is when the employer rejected that. So let me clarify.
Yeah.
Compression adjustments were being planned in the fall of 2022, right? And got implemented. And then in the fall of 22, actually in July of 22, we officially opened bargaining. And then in the spring of you're right. So the spring of 23, we settled the contract. And earlier that spring is when they rejected our proposal to address non-bargaining unit 5 experience to get additional movements on the salary schedule.
Were you present in any discussions with the Department of Education where prior experience was discussed with regards to the repricing plan?
There were multiple conversations about the plan as outlined in the memo in October of 22. So yes.
What was the state of Hawaii's position when they denied your request to have that up to 6 years of prior experience included in repricing?
We actually asked for something beyond that. We asked for them to look at all prior experience, or at least some prior experience outside of bargaining unit 5, regardless if it was at another private school, such as Kamehameha Schools, Punahou, another parochial school, or out of state. So I want to be clear that we've never advocated for some sort of division between out of state and in-state. It was always about non-bargaining unit 5 and bargaining unit 5. The employer said that they could not do that because based on the calculations and the funding, there was not going to be enough money to address it. They also did not have adequate records to look at lengthy non-experience, and it would require presenting documentation to the employer to document that non-bargaining unit 5 time, which is why we pivoted and made sure that we had addressed those things. If you look at our bargaining proposals, which I know they're not part of the evidence, in the fall of 22 and going into 2023, those were all things that we tried to address at the bargaining table. So the short answer is they say we can't do it. There's not enough money. And we don't have enough data to even cost out that cost, because the costing that was done for that bill and for the funding was based on the data that they had at that time for bargaining unit 5 experience. They're in charge, not me.
Yes.
I just noticed this is red. Have they been able to hear me? Oh. Have we been heard?
We've heard you.
once again, as your position as a chief negotiator, are you aware of a negotiation to negotiate whether repricing would be negotiated with the Department of Education?
Can you repeat that one more time? Use
Yeah.
the word negotiation a lot.
It's tricky because of what basis this is, but did the union negotiate? Oh, well, I'll make it more a little easier. Was there ever a conversation with the department where it was decided that both parties would not negotiate repricing?
There was not a negotiation that we came to some sort of agreement that this was the vehicle. The employer told us this is the vehicle that we're going to use.
At our last hearing, it was said, well, at the hearing of, at the hearing of dispositive motions, in October, were you present at the hearing of dispositive motions in October?
Oh, I'd have to look at my calendar. I may have been. I try to watch where I can. I
There
don't
was a
recall.
little block that had your name, for that one. Your counsel stated or pled, I don't know what the right word to use, that they negotiated to determine whether they should negotiate. Are
I
you
don't,
aware of any
I don't
negotiation?
recall that.
I'm gonna object to misstating what was said, and whatever was argued during the hearing on the motion is not in evidence, so I object to the form of the question.
If, Mr. Reid, if you can rephrase the question, if not, I would sustain an objection.
And also we're all shared a Microsoft Drive folder or something with the hearing videos. The videos from that date aren't readable. I think they're going to give me a copy of them at the end of the hearing today on a flash drive, so we can clarify this. Rephrase the question.
You understand why I'm asking you to rephrase the question, because you're referring to something that at this point, Ms. Eshelman doesn't have, is not in evidence. So if you have a question to ask her, just ask her the question on her personal knowledge.
Did the state ever tell you, or the union, did they ever tell you their basis for using F2 as opposed to F1 in 899?
Not that I recall. They don't. The Department of Education of the state of Hawaii don't spend a lot of time explaining their justification, right? So if you're asking me, did they explain themselves? I think that's a question you need to ask for the department, not me. I don't have knowledge of their justification.
I was asking if they told you.
Yeah, they made it clear that they were going to use F2. And that was the vehicle that they were choosing to use.
I have no more questions.
Thank you, Mr. Reid. Mr. Takei? Do you have any questions? Would you like a short recess?
No, just 1 minute while I,
Sure.
yeah, I'm sure it's,
Take what time you need.
I don't have any questions. Thank you.
Okay, thank you, Mr. Takei. Mr. Alapa, do you have any questions?
Just a couple points of clarification. I'll limit my questioning because she will be called again for the union's case.
Thank you.
Ms. Eshelman, this is more just clarification, and I know you talked about it, but I don't think you addressed it when the question was asked. You're explaining that the bill for funding for the EMP was shut down in March of 2020. Could you explain the circumstances as to why the bill and the legislative session or the legislative bill was shut down during that time period?
So, under the prior superintendent, Kishimoto, she went and informed the Board of Education she wanted to pursue this EMP. And there was a bill that was proposed, and I apologize, I don't remember the number, in 2020, and it was moving through the legislature. We were lobbying to get it supported so that we could have funding, because the biggest issue for this is always been trying to find funding to pay for some sort of adjustment. Obviously, we all know that a worldwide pandemic hit in March of 2020, the legislature shut down. I'm trying to remember, I want to say there might have been some limited emergency sessions later that year, but a full session of legislature did not open back up until the prior year. And then, of course, the actual funding for the compression adjustments was coming out of the 2022 legislature, because by the time we hit 2021, the economy had turned downwards so badly that in January of 2021, Governor Ige was threatening pay cuts and furloughs to be imposed on us. And so we were in active bargaining at that time, and we were just trying to get through enough funding to just pay for status quo.
And my last question pertains to the 3 letters presented to you. The purports to be authored by Oso Tui Jr., president of HSTA. In each of these documents, it refers to the Experimental Modernization Project, or EMP. And can you describe what the EMP was and whether this is the vehicle that was ultimately used?
So EMP was something that Superintendent Kishimoto was put forward in January of 2020. And at the point in which this testimony was written, I believe that was still something that we were advocating could potentially use. But between the time of this testimony being written and the so-called sausage that comes out the other side of the legislature, there was a determination that the employer had shifted and they were going to be using repricing as Chair Luke, who is now Lieutenant Governor, was referenced in the story that I testified to earlier.
Okay, and so to be clear, these 3 letters, at least looking at it, refers to the EMP, which is not the vehicle that was ultimately used by the employer to implement its compression fix, correct?
Correct. And I think it's important to understand that, you know, HSTA would have welcomed the opportunity to bargain, but the employer in the end, once the money got through the legislature and signed, you know, the governor signed the funding, they were very clear that they were going to use F2 and not any other method or vehicle.
And the union determined, based on the compression fixed vehicle that was ultimately used, that no benefits were actually taken away from members that existed prior to its implementation.
I have to object. This was not in the initial questioning. We didn't talk about benefits. We didn't talk about this is not on topic for the original line of questioning.
So
It pertains to negotiations with the DOE. That's what the question pertains to. If they want me to ask you tomorrow, that's fine too. But it does pertain to why negotiations with the DOE.
I believe there was some testimony already regarding benefits not being taken away, so I'm gonna allow the question.
I'm sorry, could you repeat the question?
Yeah. As part of the consultation and the analysis regarding the employer's vehicle for implementing its compression fix, did the union determine that no benefits were being taken away from members that existed just prior to its implementation?
Yes, part of what we looked at was to make sure that nobody was going to go backwards, if you will, in steps and adjustments. there's actually a chart that's attached to the October 2022 memo, and you can see that there's people that are kind of all over the place. And so there was a concern that folks who might, for whatever reason, be higher than their years of service, there was a worry that they might be adjusted downward. And so we got those assurances from the employer. And we also made it very clear that they could not do any adjustments to the salary schedule. So to our knowledge, no one was reduced in salary as a result of those compression adjustments in the fall of 22.
Thank you, that's all I have.
Mr. Reid, you have any redirect?
I have a couple. All three letters state, the Hawaii State Teachers Association, Strong Sports, the Hawaii State Teacher Association, Strong Sports, and the Hawaii State Teachers Association, Strong Sports. Does this letter speak to the Hawaii State Teachers Association or also to his personal opinion?
Sorry, does it speak to what?
Let me. Are you a member of the Hawaii State Teacher Association?
I'm staff, I'm not a member.
You are the chief negotiator.
Correct.
You are a part of the management of the Hawaii State Teachers Association.
I do supervise employees as a manager, yes.
And you're also a decision maker with the Hawaii State Teachers Association.
Depends on what decisions you're asking. In bargaining, technically, I don't have final say.
You make some decisions.
Depending on the topic, yes, I have decision-making authority. Primarily, that has to do with supervision of employees and contract enforcement.
Okay. So when the letters state the Hawaii State Teachers Association, the rest of the letter, can you not speak to does that not include you?
Objection. Cause for speculation. She already testified that she didn't review these letters. Right? This is obviously written by someone else or purports to have been written by someone else. So cause for speculation.
I'm gonna sustain that objection. Mr. Reid, maybe you can rephrase the question.
No further questions.
Mr. Takei, anything further?
No questions.
Mr. Lapa?
Nothing further. Thank you.
Board member Moipono, do you have any questions?
We can't hear you.
You're on mute. There you go.
It's been a while since I Zoomed, so you have to bear with me. And I apologize for not being there today, but in an abundance of caution, my husband did come down with COVID on Saturday, but I tested negative on Saturday and Monday. But in an abundance of being overcautious, I didn't want to expose everybody to potentials. Okay, can you hear me now?
We can, thank you.
Yes.
Okay, okay. Okay. So, that was actually Mr. Lapa's statement. Okay, in the RE1, which is the October 2022 plan from Mr. Hayashi, I guess that's when it first appeared that there was going to be a compression that was going to affect certain BU5 teachers. Is that correct, Ms.? Is that the first time?
I'm sorry, which document are you referring to?
RE1, Employers Exhibit 1.
Employers Exhibit 1.
At the top is E8.
Ah, okay. Yeah, so to my knowledge, that's the first time that it was communicated publicly that they that this was their plan in October of 2022.
Oh, okay. And then I know there's been a lot of equity and compression issues, I guess. But I don't know, and maybe you don't know either, but what years were these compression problems? You know, during what years did the teachers have these compression problems?
So there were a number of years where there were no step movements, which then that created a dynamic where people would come in and be at the same step as others. Much of that occurred in the last economic downturn, 2009, 2011. You may recall we had furlough Fridays for teachers, so there were no adjustments there. There were also dynamics in the early 2000s. So it's been about 20 years of off and on issues related to this. If you look at that same memo, it's the right one. I don't know if it's in the employers. There was a chart attached to the DOE's implementation plan that showed where everybody was placed. Oh, I believe it's E11, although this is not in color, so it's a little bit hard. But you can see the top of E11. You'll note that there's the years of service across the top of that chart, and then there are steps on the left hand. And you'll see, for example, between step 9 and 11, you have people anywhere from 3 years of service all the way up until the high 20s. And so there was a lot of compression right there, because if you go back that many years of service, there were times when there were no adjustments.
Okay, I'm not going to try to ask you to explain it because I just think you had a hand creating this chart. But,
Yeah, I mean, it's complex for sure.
I do have a lot of questions in it, but I guess my question went more towards the years that the teachers didn't get paid, and you just said that I guess between 2009 to 2011 there was no pay.
2009 to 2013, there were no step adjustment.
Oh, okay. So that's 4 years.
You may recall in 2011, the governor imposed a contract on us, and we spent 2 years fighting at this very labor board about that imposed contract, and then finally settled in 2013. Yeah, so there was that, and then there were also some years in the early 2000s where step movements didn't always occur every single year or every other year.
Okay.
So yeah, I apologize. We actually have a chart that lists all of the, like, what going all the way back to the 70s, but I know that's not in evidence, so I don't have it memorized.
Okay. So, but I guess the critical years that you folks were trying to correct would have been from 2009 to 2013. Is that correct?
That's a big chunk of it, but it was also prior to that as well.
Okay, and then
what happened was in the late 1990s, there were some significant changes to the salary schedule, and they started chopping off steps and doing various adjustments, and that created compression as well. Because in the subsequent years, there were not movements. You may recall there was a strike in 2001, and that strike in 2001 actually implemented, there was an agreement to get us off of the strike line to have annual increments subject to funding. That never was able to get funded, and so those increments didn't always happen. So it's not one singular thing, but the dynamic is that folks who were in service to the state of Hawaii in bargaining unit 5, especially mid-career people, were compressed and at the same level as other folks who were much newer to bargaining unit 5. Those at the very top had already gotten to the top before these dynamics happened, and those at the very bottom benefited from the every other year. There were step movements since 2013 up until just recently with the downturn from COVID.
Okay. So I'm just curious if HSTA figured out how many of those people that were affected by the years that they didn't get paid and who are still with the DOE and still a member of BU5. Did you folks ever try to figure that out?
People that had left service?
No, the people who actually got the compression.
Uh-huh.
And, I guess if they were around in those years where they didn't get any pay.
So there is a chart in their plan, and that chart I think is in here. It's on E21. And we had actually been advocating for this for a while because there wasn't an easy, simple fix because there's so many factors that impact folks. And so we had been advocating for this chart to be implemented. We had tried to get it at the bargaining table a couple of rounds. We're not successful. And the employer, when they came to us with their repricing fix, said, well, this is what we think is fair. This will reset everybody based on bargaining unit 5 time. And so this is a, you get a step adjustment for every 2 years. And so that chart is what was implemented. So we know over 9,000, I don't know the exact number, 9,000 some odd folks were adjusted accordingly.
Okay. I just had a question that just came up in this chart on E-013. I noticed they still have the class 2, class 3, class 4, class 5, class 6, and class 7, but weren't some of those classes deleted in that Senate bill? I think it's 2819.
So yeah, so if you're referring to that testimony, so the 20, I think there's some confusion. So folks, the testimony that had to do with that had nothing to do with compression necessarily. That was to clean up the law and, quite frankly, eliminate some of the restrictions we had under the statute. And it allowed us in this last bargain to create a class 8. So under the law, there was a limit at class 7. And so in this last bargain, because they were able to make those adjustments in the law, we were able to modify the salary schedule. So that was bargaining. That was not part of compression at all.
So now the classes are actually negotiated in the collective bargaining agreement?
So the current structure we just changed, it will actually go into effect next year. There will be a new class 8, yes. And that was only, the ability to do that was only because they made those adjustments to the statute, because the statute had some very specific language around the classes that you could have. And so we bargained that as is appropriate. That's something that you would bargain.
Okay.
But that has nothing to do with the compression adjustments. That's something separate.
Thank you for explaining. I was wondering how that affected it.
Yeah.
Okay, but that clarifies everything now regarding those classes. I think you mentioned that in you began negotiations for the new 2023-2025 CBA in 2022. Is that correct?
Yeah, so we have to give notice to the employer by June, in the month of June. So in June of 2022, we sent our official letter to give notice that we want to modify the contract, which would expire in June of 23. There are a variety of preliminary discussions with the employer, in part because of their plans to do the compression adjustments. We didn't want to start bargaining and agreeing to things that may potentially have impact. And so we agreed to postpone initial exchange of proposals, but there were a number of meetings and just preliminary discussions. And then we exchanged our actual proposals in early January of 23.
Okay, and then you, I guess you came to an agreement Or when did you?
And in April of I'm sorry, I'm thinking, yes, that's right. April of 23, we settled and then the teachers ratified just
Okay,
before the legislative session was over. And
okay,
it's a 4-year contract. We originally started, to negotiate a 2-year, but then in the end ended up with a 4-year contract.
okay, let's see now. Oh, well, I guess just during your time, because you've been with HSTA for a rather long time.
Mhm.
Do you know if DOE had ever used repricing for BU5 teachers?
There were some adjustments in the 90s, but I don't think it was done via repricing. It was done through some other mechanism, but I wasn't with the association at that time.
Okay, so as far as you know, during your time, repricing had never been done regarding
During my time with HSTA, no, this was the only time. And I've been with HSTA since 2004.
Okay. And then you had mentioned, and maybe I didn't hear it correctly, but regarding the RE1 charts, there was some concern with DOE affecting the salary chart. And so did you folks negotiate with them not to affect the salary charts?
I wouldn't call it negotiation so much as in that consultation process, they laid out their plan, which is actually the same plan that we had been advocating and trying to work for many years. And we just got assurances from them that there would be no change to the salary schedule. We made it very clear to them if they attempted to do that, then that would trigger us having to demand impact bargaining because they were looking at changing the structure of the schedule, and they did not change the structure. All they did was move people around on it.
Okay, so you folks only got some assurances, and I mean,
yes,
did you do a formal consultation, or it was just
through normal, yeah. And so you can see that reference in the memo on E20. It talks about the fact that they had consulted with us and continue to do so through the final implementation. Because there was a lot of nuances to making sure that everybody got adjusted accordingly. We had people who were on long-term leave without pay. Sometimes we had to go back in and cross-check people's seniority and time with the state and things like that. Even though it was implemented in October of 2022, we worked out with them that there would be like an appeal process. And so teachers had all the way till May of 23 to basically say, hey, I don't think I got a proper adjustment. And then those cases we could go and look at and see if there was something missing or some sort of, abnormal thing. In particular, we had a number of cases that were related to teachers who had moved to charter schools and come back. And so we had to do a lot of verification of service time within the BU. I know it's not necessarily part of this directly because the folks here who have filed the complaint are all Department of Education employees. But once the DOE implemented in October, we then had to go back to 30+ charter schools and tell them, hey, this is the process. You need to consult with us and tell us if you're planning to take advantage of this funding, because there was separate funding that we advocated for charter teachers. And then we had to go through the same process of consultation with each of those schools as we did with the department. The schools that chose to implement at the charters then all followed this same plan, which made it a little bit easier for everybody. But charter, if you've moved around charter to DOE, charter to charter, it creates some record keeping issues because the charters are not as good at their record keeping.
Okay, I see. Okay, I think that's all the questions I have. Thank you.
Thank you, board member. Board Chair O'Shea.
Oh, yeah. Thank you, Esselman. I have a couple of questions. So the decision to proceed and resolve the price compression problem that everyone, the DOE, the union, the teachers all were aware of for many years. That was not done through the we call the EMP.
Correct.
Mm.
Superintendent Hayashi chose to go a different route.
Yeah, but the EMP that was that employee
Experimental modernization
Yeah.
project.
and in chapters chapter 78. Yeah,
78, yep. Mhm.
yeah. So that was being promoted by the prior superintendent, right?
Correct, Kishimoto.
Yeah. So when the current superintendent, Mr. Hayashi, came in, he discarded that approach and he proceeded under chapter 89.
Correct.
Now, in the legislature, when it did make the appropriation, and I think also left some limiting language in a proviso tied to that appropriation. Did the legislature leave the discretion to proceed under chapter 89, or was that something that the parties had to abide by?
And I don't
If
know.
you remember,
Yeah, I know there was very limited language and it was very broad. And so that was one of the things that was, we were actually going back and asking legislature, is there anything else that we can get by way of guidance? And the answer was the language is the language and here's the appropriation, and department, will be in touch for what we're gonna do going forward.
But again, this funding and the legislation that came out of that 2022 session
Mhm.
was not for a experimental modernization project.
It was not, it was actually, the money that was allocated was to address the salary adjustments that were needed. And there was also money in there to restore what were called 21 hours, which was, job embedded professional development time that had been placed on hold during, the 2021-22 school year. And so that was a small added cost that was in there. But other than that, that was all the funding was there for. And it was made very clear to us, and I believe from the governor to the superintendent that, they couldn't go and use that for other things, that they needed to go on this track and do the compression adjustments.
And another one is, so there was no limitation on the parties, or excuse me, was there a limitation that the resolution of the compression fix would have to be done through repricing or other means? Was it tied to repricing, or did the legislature give?
I don't know if it's in the,
No, just to
in
best of
the-
your knowledge.
yeah.
Doesn't it limit?
It was made, I'll just say
Yeah.
this, I can confidently testify that it was made very clear to HSTA that repricing was the singular vehicle that the employer was going to be willing to use for this purpose. And that it was going to be initiated by the employer, and that they were not open to negotiations. Despite us asking, are there other ways that we could utilize this? And it was made very clear. And so we had this, I call it a once in a lifetime opportunity to better the lives of over 9,000 of our members. I mean, we're talking over $50 million in salary increases. Some people saw, over 10% in pay raise, where they had toiled as teachers in the DOE for many years, at the same pay rate as people in some cases with 10 years of experience, and they had 20. And so we saw this as an opportunity, and sometimes you may not like the vehicle, but we felt that this was in the best interest of our members. And so that was the decision that our union made.
Thank you.
Mhm.
Thank you, Chair.
Thank you. Ms. Eshelman, under 89.9F, which what we've been talking about, The initial sentence is the repricing of classes within an appropriate bargaining unit may be negotiated as follows, and then it has section 1 and 2. For bargaining unit 5, in which the 3 claimants belong to, is there just one class? It's all teachers that are
What-
members of bargaining unit 5?
Yes. All teachers are members of our Unit 5. The salary structure is what's called a step and lane structure. It's common in teacher schedules. So education and time experience in the unit are used for initial placement, and then you move from there based on negotiations.
And based upon your knowledge and experience, the vehicle of repricing, is that done at the sole discretion of the employer?
I will admit, I had little to no understanding of the process prior, because it had not been something since I've been chief negotiator that the employer had come to us or that we had pursued. But it was made clear to me in reading the statute that the F2 option was at the employer's discretion, and that was the option that they were utilizing.
And to the best of your knowledge, did the employer ever produce prior to the implementation of the repricing, a set of established procedures on how it was going to be implemented or how the repricing was going to be analyzed?
The only thing that I'm aware of is the information that is in that October memo. With the prior superintendent, there was a salary study done. And that's referenced in Kishimoto's memo. And so we were part of some of that work. So there was a salary study, but I don't know that it was specific to the repricing concept, but there was a salary study done in 2019.
And as part of this repricing plan, there were the non-BU5 years of experience up to the 6 years that was excluded, right?
Yes, so the compression adjustments were limited to, or the repricing was limited to an assessment of your time in BU5. So we had some folks, for example, that had been in BU3 or BU7 in other jurisdictions. And then we had folks who had other outside of state of Hawaii employment experience, and that none of that was factored in. And the reason that was given to us by the employer is that at the time they had to present the costing to the state, that was the data they used. That's the clean, hard data they had was bargaining unit 5 and years of service for those folks in the unit.
Okay, and that process, I guess, to determine, department teaching service credit, was that solely done by the employer, or was HSTA?
So we consulted, and they provided us, like a report in the fall after the superintendent presented this to the board, and essentially the board gave its blessing. We requested through that consultation to get data, but that data was done by the department. We don't actually have any records of service time, except on an annual basis. They do provide us sort of a snapshot in time, but we don't keep like retirement records or service time records. We can tell in our membership database, like when they joined as a member, or if they were in another state in the NEA of the family, but we don't have those employment records.
So maybe more straightforward, that decision to exclude that non-BU5 years of experience, was that a unilateral decision by the employer?
Yes, it was made very clear. We asked multiple times. We attempted to try and find a path, even if it was, a few years. And the answer was no, because there was not enough funding, and they didn't have the adequate records.
And I don't know if you still have it in front of you, but under 89.9, is there any provision in there for the employer to exclude people from the class that's being repriced?
Not that I know of. Yeah, I mean, like I said, I'm not super familiar with this is my first go around of repricing, but yeah.
Okay, thank you,
Mhm.
Mr. Eshelman. Mr. Reid, do you have any questions based upon the board's question?
Yes, I have a question. You mentioned that you would, discussed with the state that as long as they didn't change the salary schedule, you were not, that was fine with you. As long as they didn't change the salary schedule, that was okay. That was correct.
I think you're maybe misunderstanding. We made it clear to the state that if they attempted to change the salary schedule, that would be a basis for us to demand negotiations. There were multiple things that we discussed as to, we went through their entire plan, right? We discussed the plan that they were gonna do.
So where did you get the standard of the salary schedule was, if they attempted to change it, that's not fine.
The salary schedules in our collective bargaining agreement, and changing that bargaining agreement would require us to bargain.
Are you aware of the Chapter 89 definition for wages?
I haven't looked at it in a while, but yeah, I understand the concept that wages have to be negotiated.
Can you tell me your understanding of the Chapter 89 definition of wages?
That's the compensation that you receive. So you have to bargain that. Is that what you're asking? I'm not sure what you're asking me.
Can I read the Chapter 89 definition of wages?
Proceed, Mr.
It
Reid.
says, for the purpose of, for the purposes of this definition, in collective bargaining, wages includes the number of incremental and longevity steps. Is that the salary schedule?
The number of incremental and salary steps. I suppose you could argue it that way, yeah.
And
Because we have, well, at that time it was a little bit different, but we had step 5 to step 14B, and then a 1, 2, and 3. So, but those are not longevity steps technically, and longevity steps is actually older language that was used before collective bargaining for teachers. And incremental steps is the concept that you would move an increment. However, the state has not done that in 50 years. So you have to bargain every step adjustment now.
the second part
Sorry.
is,
If I can just get a reference to the definition that he read.
Please, Mr. Reid.
it is within Chapter 89-2 definitions. It's first definition is appropriate bargaining and arbitration for the collective bargaining. And within the definition of collective bargaining is the definition of wages.
Yes, Mr. Takei.
I believe that's inaccurate to say that there's a definition of wages when it is defining the term collective bargaining. If that's the case that he's.
This is in Chapter 89. I'm reading word for word. If you want.
You can proceed, Mr. Reid. The objections are noted.
The second item is the number of pay ranges. What does that describe an hour?
We have classes on our schedule, but we don't have what are called pay ranges. There are other units that have what are called salary ranges, but that's not something that we have.
And the last part of the definition of wages is the movement between steps within the pay range and between pay ranges on a pay schedule under a collective bargaining agreement. So is it your testimony that if the DOE attempted to change the salary schedule, which that would have triggered impact bargaining, correct?
That would be one thing that would trigger, yes.
And they didn't do that, correct?
Correct.
But did the DOE move members between steps within a pay range?
The employer made one-time step adjustments for employees.
Yes.
What's your question again?
Did the employer move members of bargaining unit 5 between the pay ranges?
We don't have pay ranges.
Could that be interpreted as moving employees up and down the steps?
We don't have pay ranges. So if you're asking me if they were moved pay ranges, no, they were not. They were given one-time step adjustments.
I'm sorry, it says, and the movement between steps.
Yeah, I mean, I'm a little bit at a disadvantage because you're reading to me the law and I'm not looking at it, and I'm kind of uncomfortable because you're asking me to interpret it. I can just tell you what happened. There was a one-time adjustment for folks in bargaining unit 5 based on their time served in bargaining unit 5. And that was done based under 89F2.
So you were, the union was okay with them respecting part of the definition of wages. But is there a reason why you didn't do, is there, I'm sorry. But yeah.
Mr. Reid, rephrase the
Yeah.
question.
Did the state address the complete definition of wages in your conversation about what you would allow as wages is described in 89.2?
Objection, calls for legal conclusion, and again, we're looking at the definition of collective bargaining, and it references, for the purposes of this definition only, wages can include so and so. So it's an incorrect interpretation of what the statute actually says.
Mr. Reid?
Collective bargaining is what the union does. That's the primary function, and she's the chief negotiator of the chief object in 89.9 is wages. This, I don't.
Mr. Reid, I'm more concerned about you asking her for a legal conclusion or a legal interpretation.
Well, did the state address?
Wait, are you proceeding to rephrase your question? Because
Am I? Oh,
I was asking you a question. I'm concerned with Mr. Alapa's objection regarding asking for a legal conclusion or legal interpretation. So do you have any response to that?
Okay.
Well, no, that's not what I'm saying.
Yeah.
I'm asking you to explain.
Well, I believe that Ms. Eshelman has knowledge of this. I believe she has the expertise to answer this question. I believe she is, as the chief negotiator, possibly the best person suited to answer this question. And she testified about a conversation about wages, and described an incomplete definition of wages. And I would like to know if the complete definition of wages was discussed with the state.
Okay, first of all, I'm going to sustain Mr. Alapa's objection. You can try to rephrase the question.
Did the state ever address with you that they were going to change wages?
So wages were not changed. The salary schedule was not changed. There was no negotiation of change numbers. The numbers all stayed the same. All that happened was one-time adjustments and movements as outlined in that memo from October of 2022. The wages, we do not go in and negotiate what teacher 1 is going to be, what teacher 2 is going to be, what teacher 3 is. Everybody's in different places on the schedule. We negotiate the blocks. The blocks did not change.
So does the HSTA not consider the movement as, what are you talking about? I'll try. Does the HSTA consider the movement between steps wages?
A movement between steps right now is generally negotiated. So a movement itself is not a change, is not wages. it is moving that individual from one block to another. So will their pay increase? Yes. Is there a cost to that? Yes. But it's not negotiating necessarily an increase in wages, like we're not adding to the number. An across the board pay raise would have to be negotiated because you're changing the blocks. The salary schedule was not changed. And as I explained before, there was a once in a lifetime opportunity to use a vehicle that the employer has said, hey, we want to do this. We consulted. We felt it was in the best interest of our unit to do that, and we agreed to it. But there was no need to negotiate because there was no change in the salary schedules.
The once in a lifetime opportunity was to move. Would it be fair to say that the once in a lifetime opportunity to get the compression adjustment resulted in the movement between steps within the pay range for bargaining unit 5?
I'm gonna object, you keep saying pay ranges. She's very clear, asked and answered, that does not apply to the HSTA and the CBA.
I'm using terminology in the law.
And the wages, it says wages includes these things. It doesn't apply to every bargaining unit. Every bargaining unit can bargain whatever they need in their contract. This doesn't, again, he's using a definition as it applies to everyone. It includes these things. It's not all exclusive.
There is no limiting language in this. There is no limiting language. What the salary structure of bargaining unit 5 is closely, if not exactly, resembles what this describes. And one document cannot describe potential possibilities for all the different kinds of pay schedules. The intent of this definition is clear, that the movement between steps within the pay range, salary schedule, class is what it means. I'm asking if
So
we move people
Well-
up and down.
Mr. Reid, I think Ms. Eshelman already testified that there is no pay range. That pay ranges don't apply to the HSTA. So I guess that sort of goes to the crux of Mr. Alapa's objection, that it's, if you can try to clarify the question, I think it's confusing right now because you're using the language from the statute, which is in general, and trying to apply it to this specific situation. So I'm not prohibiting you from trying that. I just, if you can try to rephrase the question based upon the testimony that's already been given.
Give a short recess. 2 minutes.
Yes,
Sure.
we'll stand in recess.
I know this is recording, but thank you.
Can you hear me now?
I can.
Yeah, mine was muted. Okay.
Okay, thank you.
Okay, can you hear us now?
Yes, thank you.
Thank you for letting us know. Looking for his question right now.
I wrote it down and then it disappeared. As things do.
Take your time.
Or maybe I apologize.
That's okay. Take your time.
Um, um, wait. No further right now.
Thank you, Mr. Reid. Mr. Takeda, do you have anything based upon the
Yes,
board's
sir.
questions? And
Yes, just a few. So, it's your understanding that repricing was accomplished under 89.9 F?
F2, correct.
Has repricing ever been accomplished through collective bargaining?
There is the F1 option, but not with my bargaining unit, to my knowledge, since I've been chief negotiator.
Okay. Earlier. Okay, has there been repricing done to your knowledge before you've been chief negotiator?
And not that I know of, not for bargaining unit 5. But again, it could have. I know there were some adjustments that happened in the 90s, but I'm not exactly sure how that happened.
Okay. Is movement on the salary schedule something that comes up regularly for collective bargaining?
Yes, since the late 70s, the legislature required that we have to negotiate any step movements going up.
And is there an established practice for collective bargaining?
For the process of collective bargaining, yes.
Mhm. Okay. And does that typically occur once within every 5 years?
No, it typically occurs every 2 years with the biennium budget for the state.
Okay, so within a span of 5 years, there would usually be an opportunity to collectively bargain.
Correct,
Okay,
multiple times.
and okay, that's all. That's all the questions I have.
thank you, Mr. Takeda. Mr. Lapa, you can-
Yeah, I just have one area of questions, if I may.
yes,
Session, this kind of supplements Chair O'Shea's questions. Can you turn to unions or exhibit U19? Or
Looks like a bill.
so this purports, or this has been entered into evidence, it's titled on the bottom HB 1600.
Oh, there we go.
2022.
Mhm.
If you can turn your attention to section 12.2, is it your understanding that the sum noted here is where the costs for the repricing came from?
Yes,
And it states that that money shall be expended for repricing and other cost items pursuant to chapter 89. Did I read that correctly?
correct.
That was your understanding as to what the funds could be used for during this time period?
Correct.
That's all I have. Thank you.
okay, thank you. Since this is your witness, Mr. Reid, anything based upon the questions of Mr. Takeda and Mr. Alap?
No questions.
And Ms. Eshelman, excused,
Thank
the
you. Chair.
witness, thank you very much.
Do you folks want me to put leave the 89.9 up here?
You can leave it there. Thank you.
Oh, that one's mine.
You
Yeah.
want it back?
Yeah. I'll give it back if there's a reason.
Thank you. Mr. Reid, who would be your next witness? You're calling yourself?
Yeah.
Remember, just for housekeeping purposes, does the board usually take a lunch break at noon?
Yes.
Okay.
Hey, Mr. Reid, do you solemnly affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may proceed.
And I can I can use exhibits.
Yes.
I'd like to draw our attention to CU1 -01. This exhibit, well, here's a housing question. Do I need to ask to accept them into evidence or just talk about them? Is there a procedure for introducing exhibits? Grudges.
I believe your CU1 is already in evidence.
Okay. So this document tells us that around or before May 3rd, repricing was the vehicle to solve the compression fix. It also shows that the union has, it also shows that the union has for years, even decades, requested a fix to salary compression. I'm establishing a timeline here because the timeline is important. So here we have the end of the process, start at the end and go back to the beginning. We have repricing, May 3rd. Word of the year is repricing. Page 2 says, this year it should be repricing. You don't need a new law. You don't actually need new legislation to do this, and the governor can do it right away.
Sure. This is, I mean, basically just giving a speech. Is there, you know, if the testimony or question is improper, it doesn't give me the opportunity to object.
Mr. Reid, if you're allowed to give a narrative of your testimony, if you want to refer to exhibits, that's fine.
Okay.
It makes it a little more difficult on the other parties if you're just going to sit there and read from exhibits that are already in evidence.
Okay, so make narrative, make reference to, don't read from. I don't know how this works. So
Yeah,
I'm
no,
trying
I
to
understand, and that's one choice.
Yeah.
If you can give your narrative, if you're going to refer to exhibits, refer to
Okay.
simply reading from the exhibits that are already in evidence.
Unnecessary.
Well, not unnecessary, but it makes it difficult for the other parties.
Okay.
So
I think
you
I
can proceed.
have a better understanding now. Thank you.
Sure.
The timeline is simple. This exhibit says that repricing, the repricing was introduced into the compression fix sometime around May 3rd, prior to May 3rd. And for now, that's what we're going to say there. So if we look at the beginning of the process in 2019, according to the Board of Education memo, it was an EMP. And if we look, and then we look at the Board of Education memo in January of 2022, it's an EMP. I'm sorry, January of 2020 is an EMP. We go on hiatus for a while because COVID, we come back to it, and we get to SB 2819, which originally had the intention to appropriate money. And that is C0016, appropriates money for an EMP. Right? And then we get the next, and the date on that one, that one's actually dated. The date is January 21st, 2022. We are an EMP. The current superintendent intended to do an EMP. Is the bill, this EMP. Right, as we progress to the next version of the bill, the dates come off of this, off of the front, but the metadata from the PDFs from the legislature put this one in about February. And still EMP in February, EMP in 2019.
If you could slow down, I'm trying to keep up with his pages. I just can't.
Yeah, you need to refer to
Okay.
what pages of the exhibit
So
that you're referring to, and Mr. Reid, I'm just gonna caution you again about simply reading from the exhibits that are already, we have it.
Yeah.
And we can read it
Yeah,
ourselves.
yeah.
So if you want to continue
Okay.
with your narrative.
All right, so I won't read from it, but EMP also in that one. Actually, every version, not every, the last one makes no reference at all to authorizing anything because under repricing, you don't need a new law. The next to last one states it has.
Sorry,
Can you tell me what the last one is?
Yeah,
A
Mr. Reid,
SD,
you need to refer to the page number
Oh,
of the
sorry.
exhibit because I'm having a hard time following you all.
Okay.
Because I don't know what you're referring.
I've said it 1,000
And-
times to me, so I'm quicker
And
than.
then, Mr. Reid, take your time.
Okay,
You can, I know it feels uncomfortable, but just take your time.
okay,
You're teaching us.
I
Thank
got you.
Yeah.
Done that once or twice. Okay. So the first three,
Can you give us the page?
yeah, so they're all gonna be C. 29. Right, yeah. Yeah, sorry, C30 says, on C30, it says the purpose of this act is to fund an experimental modernization project. At C30, the next time it's referenced is on page C37. Top line number 1. Fund an EMP. We look forward into the next version on page. That's the same one. Get longer. It changes to an MOU on C48. And by the time we get to SD2, HD2, we are in the month of March. In the month of March,
What year?
2022.
Thank you.
So we're in EMP at the very beginning until March. Once we get now in March, there are a couple versions. If we look on page. So we go to the last one on page number. Well, the SD2, HD2, CD1 on starting on 56 no longer references any project. An EMP, MOU, it's no longer here because this is when repricing was fully engaged. That was the vehicle that was going to happen. So it drops out of this bill. And to go back to the beginning, May the 3rd is when the HSTA, and that is 10001, is when the HSTA proclaimed repricing. Repricing was the language we're using this year. And that timeline is important because the entire case is at the discretion of the employer. That is the card, the bottom of the house of cards that cannot fall. And 89.9F2 as conditions. The repricing of classes based upon the periodic review shall be at the discretion of the employer. don't have to look at it. That's what it says. Notably absent from this folder of exhibits is any documentation whatsoever that would allude to the presence of established procedures. As a teacher in the Hawaii Department of Education, I can tell you the DOE likes to write things down. I get a red folder, thick. I'm told you have to know what this says. You can choose not to read it, but you're responsible for what this says. And as a band teacher, I take lots of field trips, and the field trip manual is huge. It's huge. The regulations are written down, clearly written, expectations, consequences, what I have to do. Department of Education has a very rich history of paperwork, and they have produced nothing that would lead us to the conclusion, I don't know if I can say this, but that the employer established procedures. As the law says, well, I'll go back a sentence. The employer, the jurisdiction shall ensure the establishment of procedures to evaluate the repricing of the bargaining unit. That is a requirement clearly written in the law. It's there. I put it in the back of this one. I know my folder has a couple of extra notes in it. I'll read it word for word because I don't have it. It's over there. But that is what is written in the law. You have to establish procedures for a periodic evaluation of the repricing of the bargaining unit. And notably absent, not there.
I'm gonna object to statements that alludes to the employer not having these documents. It lacks foundation. I'm not aware of complainants in this case making a document request. So this line of statements it lacks foundation at this point, calls for speculation.
Mr. Reid?
Yeah,
Let me ask you
Yeah.
this, Mr. Reid. When you're saying there's no documentation of established procedures, are you simply just talking about what exhibits have been submitted in this case by the parties?
yes. I'll rephrase. There are no exhibits accepted as evidence in this case that there are any established procedures to evaluate the repricing of classes. And it's very explicit. It's very explicit what has to be there. And there have been no submitted documentation in this case, has not been pled, has not been submitted in this case, that any of that happened. Also, it has not been submitted into evidence that there were no results from the periodic reviews that will be claimed to have happened are here. They're not entered into evidence. And those are two legal requirements to grasp the power at the discretion of the employer. The law does not say the repricing of classes based upon the long time lobbying by the Hawaii State Teachers Association shall be at the discretion of the employer. It's not what it says. And they have.
Hold on, Mr. Reid.
Again, I'm gonna object to the extent that he's making legal conclusions that there was some type of obligation at this point in the case that the employer had an obligation to produce this documents. They have not put their case in chief on yet. They have not called their witnesses. So it's improper to make those types of legal conclusions. At the end of the day, it's complainant's burden to prove these points during this case in chief.
Mr. Reid, stay away from the legal conclusions regarding different matters.
Okay. I said they weren't here. I don't think I may have.
Were you?
I was saying that they have not been submitted, and I've just been speaking to what has been turned in. And when we, well, and they can't submit extra exhibits after the previous
Mis-
hearing. Yeah, I'm
Mr.
sorry.
Reid, that is something for the board
Okay.
to decide when it comes up, so
Okay.
just continue with
Okay.
your testimony.
So based on information, so moving forward. All right, I submitted a grievance. We went through the grievance process. I got my grievance response from the state of Hawaii. In that grievance, we can look, that's one of the exhibits. Lawyer near the front. RE2 on E23. And in the discussion section, well, this the response I got from the state was that the state worked with OCB, Office of Budget and Finance. Sorry, OCB is Office of Collective Bargaining, and BNF, Office of Budget and Finance, at the creation of this plan. And that led me to believe that those two departments agreed with this, with the repricing process as done by the department. That's what I first got the impression from reading it. I did some research, and back to my exhibits. It's going to start at CU 10, which is about 73. And there are 6 of these letters. I'm not gonna read all of them. They all pretty much say the same thing. I'm gonna go to the last one, which is dated April 1st.
What page, Mr. Reid?
Let me get to it. April 1st, C84. The latest one, it's the last one submitted by the Department of Budget and Finance. And about halfway, a little over halfway down page 84, it says BNF has serious concerns because this bill puts the cart before the horse. They had serious concerns that this did not follow the intent of the collective bargaining laws. And when I read one document from the state that says BNF, we worked with them, didn't explicitly state that they approved of this, but they say we worked with them, it was done correctly, this is the response to your grievance. And then we find evidence that they had serious concerns, very serious concerns. If we look at the Office of Collective Bargaining, their last one, which is on what's the date? Yeah, C77. One sentence, the Office of Collective Bargaining respectfully opposes.
Board member, if we could just
Yes.
pause between the pages.
Oh, sorry.
Trying to keep
Yes.
up.
77.
Slow down a little bit, Mr. Reid. Just relax. I understand. Take your time.
Yeah.
Is C77?
Here it clearly says they oppose SB 2819. And they list why, they have the reasons why. There's a whole litany of things there about how they oppose it. And I found it initially very confusing how my step 1 decision letter says, we worked with these people. And we collaborated, whatever verb they use. We worked with these people to make this plan, and our plan was done correctly. So here's our decision. And then I find out that it appears to me, well, this is what they said. This is what they said. And I'm going to read it, but there's a whole litany of things, and there's why they don't agree with that. So I find so moving on. Look at the 88. This is simply to say that it was advertised to me as a teacher with prior experience. Why I would have my prior experience recognized. I've been teaching at this point 16, 17 years. We count the first year I did long-term subbing. 16 years I've taught in Kentucky, Tennessee, South Carolina, Hawaii, taught in 4 states. I've got teachers in my family. I have been in the education, I've always been in school, either as a student or as a teacher. And when a teacher reads what it says under prior experience credit, it leads me to believe, and it leads me to believe that my experience was good forever. There is no language in this which states exclusively under prior experience credit. There's no limiting language. There's nothing in that paragraph for prior experience credit which would lead a teacher to believe that their experience could be taken away. It's not there. We were told to come, we value your experience, come and teach the children of this state, and we will treat you and we will value 6 years of your experience. I had 9. I had 9 years of prior experience. I took the hit of 3. After you're losing 3 years isn't the worst thing ever. I can come do this. It's a small setback. Had I known that I was gonna have all of it taken away, I would have seriously reconsidered whether I sold my house, and I would have seriously reconsidered. I gave up everything.
So Reid, you want to take a break?
Yeah.
No, we're gonna take our lunch break.
Oh,
No, it is lunchtime.
let's see.
Yeah, we'll return at 1:30. We'll stand adjourned.